into the hands of a certain number of inhabitants, there results a monopoly in their favor against the rest of the nation, to which they do not wish to submit. Well, they have shared the land. I admit that therefrom results a more powerful organization of labor, and that this method of distribution, fixed and durable, is advantageous to production. But how could this division give to each a transferable right of property in a thing to which all had an inalienable right of possession? In the terms of jurisprudence, this metamorphosis from possessor to proprietor is legally impossible. It implies in the jurisdiction of the courts the union of possessor and petitoire, and the mutual concessions of those who share the land are nothing less than traffic in natural rights. The original cultivators of the land, who were also the original makers of the law, were not as learned as our legislators, I admit. And had they been, they could not have done worse. They did not foresee the consequences of the transformation of the right of private possession into the right of absolute property. But why have not those, who in later times have established the distinction between jus in re and jus ad rem, applied it to the principle of property itself? Let me call the attention of the writers on jurisprudence to their own maxims. The right of property, provided it can have a cause, can have but one dominium non potest nisi ex una causa contingere. I can possess by several titles. I can become proprietor by only one non ut ex pluribus causis idem nobis deberi potest, ida ex pluribus causis idem potest nostrum est. The field which I have cleared, which I cultivate, on which I have built my house, which supports myself, my family, and my livestock, I can possess, first, as the original occupant, 2d, as a laborer, 3d, by virtue of the social contract which assigns it to me as my share. But none of these titles confer upon me the right of property. 4. If I attempt to base it upon occupancy, society can reply, I am the original occupant. If I appeal to my labor, it will say, it is only on that condition that you possess. If I speak of agreements, it will respond, these agreements establish only your right of use. Such, however, are the only titles which proprietors advance. They never have been able to discover any others. Indeed, every right it is Pothier who says it supposes a producing cause in the person who enjoys it. But in man who lives and dies, in this son of earth who passes away like a shadow, there exists, with respect to external things, only titles of possession, not one title of property. Why, then, has society recognized a right injurious to itself, where there is no producing cause? Why, in according possession, has it also conceded property? Why has the law sanctioned this abuse of power? The German Ancillon replies thus: some philosophers pretend that man, in employing his forces upon a natural object, say a field or a tree, acquires a right only to the improvements which he makes, to the form which he gives to the object, not to the object itself. Useless distinction. If the form could be separated from the object, perhaps there would be room for question. But as this is almost always impossible, the application of man's strength to the different parts of the visible world is the foundation of the right of property, the primary origin of riches. Vain pretext. If the form cannot be separated from the object, nor property from possession, possession must be shared. In any case, society reserves the right to fix the conditions of property. Let us suppose